Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. I've come across a book which is really rather interesting. It's one that I'm not quite sure how many people will find it particularly relevant. I certainly found it interesting. Bearing in mind when I looked at it, I went back to my time during the bar vocational course, it was then called, training to be a barrister, and thinking about such things as doubt and proof, because they are big areas, and when you're quite young, a bit green and not quite so sure of what's going on, these areas can sometimes be a little bit of a high mountain to climb. And I say that because you never quite know what the clients and the people you're cross-examining are going to get up to. Now, this book has come to us from Ashgate Publishing Limited. It's part of the Juris Diversitas series. It's an ebook as well. The title of the book is Of Doubt and Proof, and the subtitle is Ritual and Legal Practices of Judgment. Now, you can see immediately there could be some rather interesting comments to be raised here about the way in which we go about our business. You see I'm wearing some interesting clothing, and you can see that there are substantial comments about the anthropological behaviour perhaps of the judiciary. Now, I'm not going to make any comments about my learned colleagues, but what I would say is that the book, edited by Daniela, Berti, Anthony Good and Gilles Tarabout, I hope I pronounced the names correctly, I think is a wonderful contribution to what we've got at the moment, although this will be for, I suspect, for a specialist audience to read. But it's an interesting book. Now, Elizabeth and I had a long chat about this because she was quite interested to think what my view might be, and we did come up with a title for our review, a fascinating contribution to the debate on the concept of proof and doubt. Because remember one thing, we don't ever, when we're making, when we're actually dealing with a case, make any real decision about what we think of clients. I certainly don't. I mean, if I did have a view about a client, I'd keep it to myself, but I don't normally. I just get on with the job. Because actually, if you do that, it's a much better way of dealing with it, because you start thinking, oh, well, you know, that's... I mean, clearly sometimes the evidence is such that you think, well, can you in all honesty actually countenance that as an argument to put forward? The thing is, if you're instructed to do so, and if that is the line that is being run, you've got to recognise where you are. Now, clearly you can advise the client, but at the end of the day, when it comes to doubt and proof, you must, of course, have the experience, and you must be able to identify where you're actually going with a case. That's all I'm going to say about that. But what I will say is I'll show you the book. Here it is, hardback. There's the front, there's the side, the spine, and then there's the back. Now, the front is, the front cover is The Incredulity of St. Thomas by Caravaggio. Now, for those who don't know who St. Thomas is, he is Doubting Thomas, who said to Jesus, I don't know that you were executed by crucifixion. I want to see your wounds. I want to see the holes in your hands. And that's what you've got there. Now, I say that because that's very important, because that is proof for Thomas that Jesus had been murdered and had come back from the dead. That's the basis of the story. Now, you can see from that that the proof, therefore, is the final ending, if you like, of any doubt. Now, let's have a look at the book itself. There is a short index at the back, and it's about page numbers. Then you've got, right at the back, an afterword. You do have some subheadings all the way through. There isn't, there's a little bit of footnoting, but really not that much. There's no paragraph numbering, but there are subheads. At the front, you've got some quotes about the book. Those quotes actually appear again on the back as well. You've also got, there is the Juris Diversitas list of publications with the series editors. I'm not going to go into any great detail there. This is the actual front cover of this book. Then you've got here, as I've indicated, it's actually an ebook as well. All the information about the ebook is there, if you need any of that, plus the relevant numbering. Then you've got the actual content sections and the people who've written the various 8 chapters. You've got an introduction, then at the end you've got the afterword, and you've got an index, and you've got a few little lists of figures, then a note on all the people who've contributed. Again, I can't go into too much detail because there are a lot of people involved in this, and I'd like to thank all of them for a tremendous contribution to the debate. Then there was a foreword, which had been translated from French by Anthony Good. The foreword is there because obviously there is a linguistic issue here. That foreword has been written by Antoine Garapon. And then there's the introduction, Technologies of Doubt in Law and Ritual. Now, what is this all about? Well, actually, to a certain extent, it's about anthropology, which you may think from a jurisprudential point of view is, what on earth has this got to do with my practice? Well, actually, it's got more than you would think, because at the end of the day, I said you don't make a value judgment about your client. I don't say, look, he's awful, I'm going to deal with him, or he's dreadful, or, oh, the poor person, he really needs help. I don't look at it that way. I look at the problem they've got with what I might be able to do by way of assisting them, normally in some form of advocacy. And I don't really look at whether I have doubt what they're saying, because it's not for me to make that decision at the end of the day. Although I can advise sometimes if something is so incredible, it's ridiculous. I have to say, well, I don't know that people are going to believe you if you say that. You know, I was down at the Needle Arms in Bromley at the time of the incident, you know, the sort of rumpole type of thing you've got, when it's quite clear that that cannot be the case. And we do have a lot of cases, I get them in the road traffic area, where you get a lot of really difficult stuff concerning proof. Then you get down to the proof itself. I'll take the RTA ideal first, because when you have a collision, what is the judge going to do? He or she's got to find, unless it's contributory negligence, where it's a 50-50 or a split, he's going to find, or she's going to find, for one side or the other. And the question then is the proof. Normally, for instance, in an RTA matter, it's going to be where the damage is, how the damage was caused, and where the position of the vehicles will be, whether they're stationary, moving, or whatever. Now, you can see then that that's all about proof. And when you have, as you do quite often in the pleadings, the party is put strictly to proof on something, that means you've got to prove everything. That's when the problems start. So this is what we say about the book. Having got that little bit set, so you've got the scene set as to where we are, because this is not an easy book. I didn't find this the easiest book in the world to read, I have to say. This is what we say. Doubt and Proof is a title that could have come straight from Dostoyevsky, but no, this book is in fact a scholarly examination by 10 international contributors, including 3 editors, of doubt and proof, that often perplexing duality, which, like it or not, is part and parcel of the process of judgment and judging across a range of contexts, from judgments in a court of law to, when you come to think of it, decisions by cricketing umpires, or indeed Taiwanese diviners, as 3 of the distinguished contributors to this book have set out either to discuss or prove. Remember what I said earlier about incredulity? Bear that in mind, and don't be cynical about it. The contributors are a distinguished bunch indeed, in my view, with university backgrounds ranging from, for example, Copenhagen and Edinburgh to Hamburg and Oxford, and a range of academic institutions in France. They bring a dizzying, diverse array of impressive credentials to this particular forum of discussion inquiry, one of which I think is quite actually worth exploring in a bit more detail. As the editors explain, the book is based on a panel of the same title which took place during the biennial conference of the European Association of Social Anthropology, ISA, at the Université Paris-Ouest. I'm sorry, I'm not going to try and pronounce it in French, at Nanterre in 2012, recognised as, quote, the principal event in the European conference calendar, and organised around the theme of uncertainty and disquiet. The conference, to summarise, set out to examine ways in which notions of doubt and states of doubting have generally been understood across a variety of academic disciplines. Now, we're not talking here, before I go on, we're not talking here about the standard of proof in terms of a balance of probabilities or beyond reasonable doubt. But of course, when you're looking at certainty, uncertainty, disquiet, you then have got to remember if it's a balance, it's 50-50, but it's way up here if it's beyond reasonable doubt. You've got to therefore bear that in mind if you, for instance, you're addressing a jury on a particular matter. Like, again, this may be of some help to those in the criminal jurisdiction. Fundamentally, say the editors, the individual contributions reveal and illustrate the range of techniques employed in dispelling doubt, not only in ritual context but in formal legal procedures, as the subtitle indicates. The aim, of course, is that they add is to deepen theoretical understandings of the social role of doubt, both in social science and in law. Now, this is where I have a slight difficulty, because we don't really think about it like that. If you're addressing a jury, for instance, or you're trying to put a particular point forward, you're not really thinking about the social background of an individual, because normally it's about common sense, putting it bluntly, and how far you might go. But having said that, it may well be with some facts that you have at your disposal when you're dealing with a case, it may well be that something that sounds absolutely ridiculous can actually happen. In other words, you couldn't make it up, to use Richard Littlejohn's favourite phrase. So one could remark here that it is the lawyers of this world, as well as the judges, of course, who would, we think, derive maximum fascination from this admittedly multidisciplinary overview of doubt and proof that is tackled from a number of different viewpoints, and certainly from, yes, different disciplines, including law and jurisprudence, obviously, to both social science and anthropology, which is not quite so obvious. The end result emerges, in the words of Deborah James from the LSE, a rigorous contribution to the novel field of the anthropology of doubt and evidence, which demonstrates how law and ritual have much more in common than formerly supposed. An interesting point of view, but frankly quite a high-flown academic approach, with great respect to Deborah Jones, but thank her in the same time for the fact that she's put that view forward. A recent publication from Ashgate's Juris Diversitas series, then, this is a stunningly original book that should certainly occasion endless debate at high tables and in common rooms, not to mention robing rooms in court buildings, where English barristers strive to ensure that all cases, and without exception, that justice is done. And again, that's the point, because of the issue of proof itself and the requirements, depending on the actual tribunal you're in, civil or criminal, as to what level you've got to attain in order to make your case, as it were. So whilst agreeing with much of the content of this book, they, and certainly the judges, would say almost without any doubt whatsoever that in the common law it's the quality of the argument that refines the decision. See, for example, Anthony Good's article on the benefit of the doubt in British asylum claims and international cricket, touching on standard of proof, reasonable doubt, credibility and so forth. This is one of the most lucid explanations of the concept of the benefit of the doubt in common law systems that you're likely to find anywhere. Again, an area I think a criminal practitioner would find very helpful to look at. Rooted in comparative law, then, the book will be of interest to a wide range of academics, students and practitioners, particularly those with an international orientation, who wish to keep abreast of current thinking in this and other related areas of law. And the publication date is cited at 2015. I'm recording this in the middle of 2015. I think the book has an historic interest to it because it's a longer term book. There it is again, hardback, front, St Thomas on the front, and again you can see the back. Just opening it in the middle, chapter 4, when judges feel misjudged, encountering doubts in Ghanaian courts. So you've got a nice mixture here of the whole area. Now, we mentioned cricket. There we go, the benefit of the doubt. I must show the nice photograph there of those of you interested in cricket. You can see actually the picture. Cricket has changed so much over the years. and The Benefit of the Doubt in British Asylum Claims and International Cricket, which I mentioned earlier by Anthony Good, is well worth reading, whether you like cricket or not. Whether if you come from a jurisdiction where there isn't any cricket and you don't know what it's about, again it's worth reading. Thank you to the editors anyway, and also to Ashgate. It was a real challenge looking at this book, but it was worth it because it was different from what we normally have. So thank you to all concerned for an excellent publication. Bye-bye.